Hi guys, this podcast is related to international humanitarian law, which is an area of international law. So basically, international humanitarian law is a set of rules which seeks for humanitarian reasons to limit the effects of armed conflict. It protects persons who are not or no longer taking part in hostilities. In other words, IHL is an area of law which seeks to limit the effects of warfare. And all this is achieved by restricting and regulating the means and methods of warfare available to combatants. It is important to note that IHL is a special law which starts applying when the conflict starts and it ceases to apply when the conflict ends. So the IHL is also known as the law of war or the law of armed conflict. To understand the difference between international law and international humanitarian law, we should look into the difference between them. International law is basically something which is defined as body of law that governs legal relationship among members of the international community and international organizations which are created by states like United Nations and World Health Organization, etc., etc. International law retains a structure which is fundamentally different from municipal law or national order. The major difference is that international law is consent based and the law which is agreed upon by states. Hence, international law is binding upon states only if they agree upon them, except in the cases of customary international law or jus cogens. IHL is a part of international law which has been agreed upon by states to reduce sufferings during armed conflict. Uh, it comprises of certain treaties, customs, customary rules which consist of state practice considered by them as legally binding and general principles. Hence, IHL exemplifies all weakness at the same time the specificity of international law. It was born as a law regulating belligerent interstate relations, even when the very existence of a state is at stake. IHL is distinct from humanitarian morality or simple dictates of public conscience. It is important for international law to have rules concerning armed conflict. International law is a general law and IHL is a special law. International law is therefore applicable as to complement IHL. The rules of international law governing the responsibility of states are complement to specific rules on general criminal responsibility under international humanitarian law. Generally, there are confusions between two Latin phrases, which are "jus ad bello" and "jus ad bellum" and "jus in bello." Let's have a look into these two phrases. So, the international legal framework governing armed conflicts can be classified into three regimes. The first is Geneva Conventions and additional protocols. The second is the UN Charter, Article 24 and Article 51, which are related to the use of force. And then we have international human rights law, which is comprised of UDHR, ICCPR, and ICESCR. It is to be taken into consideration that IHL applies to armed conflicts. However, it does not regulate whether a state may use force against another state. This is governed by important but distinct part of international law set out in the UN Charter. The law on the use of force or the legality of force is is known as jus ad bellum. The use of force between states is presently prohibited under Article 2.4 of the UN Charter. But after the new regime of prohibition, jus ad bellum has changed into jus contra bellum, which means the law on the prevention of war. The exception to the prohibition is admitted in cases of individual and collective self-defense under Article 51 of the United Nations Charter. So even though it's prohibited under Article 2.4 of the UN Charter, it can be used as a self-defense. Having said that, let's turn towards another issue, which is the similarities and dissimilarities between human rights law and IHL. Well, basically, IHL seeks to protect persons who are not or are no longer taking part in hostilities, and to restrict the means and methods of warfare employed by both parties. Human rights law has also the same purpose. It is to protect the people in all times. However, there's a difference. The key difference between both of them is that international humanitarian law is only applicable when there is an armed conflict, either of international or national nature. The international human rights law instead is applicable in all situations. So, this is where we would wrap up our lecture today. Hope you liked it, and we will meet you soon with our next lecture. So, be with us. Thank you so much.